Welcome back to the Deep Dive. Today we are breaking down a really important 2025 Supreme Court judgment. It's Sanjabij Tari versus Kishore S. Borcar. We're looking at the full text of the ruling and, our mission is to understand how the court just completely changed the playbook for check bounce cases.
It's a critical update, and it really gets at a situation that I think so many people can relate to. The friendly loan that goes completely wrong.
Oh, absolutely. You lend a friend cash, you're trying to help them out, and then they default.
And then they turn around and use the law itself to claim the debt was never real to begin with.
Right. Let's get into the facts of this case because they're pretty stark.
Yeah.
You have the lender, Sanjabij. He's a salaried guy earning, about Rs. $2,300 a month?
Yeah.
A very modest salary.
Very modest. And he claims he lent his friend, Kishore, 6 lakh rupees in cash.
6 lakhs. So when Kishore's check bounced, the fight wasn't about the signature. Kishore admitted it was his.
Yeah, that's key. Instead, his entire defense was an attack on Sanjabij's financial capacity.
And you can almost see the logic, which is why the High Court initially sided with him.
You can. The difference is just. It's huge. The borrower's defense was basically, look at his payslip. There is no way a man earning so little has 6 lakhs to lend.
Therefore, the loan never happened.
Exactly. And the High Court acquitted him. They said Sanjabij couldn't produce this perfect paper trail for where the cash came from. It felt like, a common sense win.
But the Supreme Court stepped in and overturned that acquittal. And this is where the legal stuff gets really interesting. They went right back to the law, to Section 139 of the Negotiable Instruments Act.
The presumption of debt.
Precisely. Once a borrower says, yes, that's my signature on the check, the law just assumes there's a debt.
It completely flips the burden of proof. It's almost like, for this specific issue, you're on the hook until you can prove you're not. The court said you can't just poke holes in the lender's salary. Not nearly enough. The borrower has to bring actual concrete evidence that the loan doesn't exist.
That's a high bar. But the part of this that I think is a real game changer is how it deals with what we're calling the tax loophole. The borrower argued that because the loan was in cash and over as $20,000, it actually violated Section 269 SS of the Income Tax Act.
Right, a very common defense strategy. The logic is this was an illegal transaction under tax law, so the court can't enforce an illegal debt.
And some high courts had actually agreed with that in the past.
They did. The P.C. Hari judgment is a famous example, but the Supreme Court has now explicitly overruled those decisions.
So what's the new rule?
They drew a very hard line. Violating the Income Tax Act is one thing. That's between you and the tax department. They can penalize you for it, sure.
But it doesn't just make the debt disappear.
Not at all. Bouncing a check is a separate offense. You can't use a tax issue to get out of repaying someone who lent you money. The two are now completely separate.
It feels like the court did this because the system is just drowning in these cases.
Oh, absolutely. That's the context here. There are over 33 lakh pending check bounce cases. It's a logjam. So this judgment also tries to modernize things.
Like the serving of legal notices.
Finally, yes. They've mandated that summons can now be served legally through WhatsApp and email.
So no more "I never got the notice" excuse.
Yeah.
If they've got the blue ticks, you're on notice.
It kills that delay tactic. And even more aggressively, they've introduced what they're calling compounding costs.
Which is basically a penalty for wasting the court's time.
It is. It's a tiered system to push for early settlements. If you, the accused, settle right away before evidence starts, 0 penalty.
And if you drag it out?
If you drag it out to trial, you pay the debt plus a 10% penalty on top of the check amount. If you appeal, it goes up to 15 or 20%. Time is literally money now.
That's a huge incentive to settle. So let's bring this all home for our listeners. If you're a lender, what's the big takeaway?
Document everything. Even with this ruling on your side, document your source of funds. Bank withdrawals, loans from family, anything. Sanjabij had to go all the way to the Supreme Court.
Good point. And for borrowers?
The shield is gone. You can't hide behind a tax technicality to avoid paying someone back. And for everyone, really. If you get a legal notice on WhatsApp, deal with it.
Don't ignore it.
Do not ignore it. Silence is much more costly now.
Which leaves us with a final thought to chew on. The court has said technicalities can't be used to break trust. But in this new world of digital summons and separated laws, the system demands more from you. The law will protect your right to be repaid, but are you organized enough to prove your case when it really counts?
Something to think about. Stay informed.